Many homeowners in cities like Vancouver or Toronto eventually look for ways to secure their family's financial future. A common approach is to take out a pen and add a spouse or a child's name directly to the property deed. People often treat this process like updating an emergency contact form. You fill out a few government documents, pay a minor administrative fee, and assume the job is done. But Canadian property law views this action entirely differently. When you add a name to a title, you are officially disposing of a portion of your real estate and legally transferring ownership of that portion to someone else. Doing this blindly triggers consequences you might not see coming. It can generate immediate, unexpected tax bills and set the stage for complex court disputes over who actually owns the home years down the line. A property deed operates as a legally binding financial anchor. The legal system treats spouses and adult children very differently when you decide to move that anchor. Let's start with a highly common scenario: a homeowner deciding to add their spouse to the deed of their principal residence. Often, they do this simply for logistical convenience or a sense of shared ownership. The immediate financial consequences of that decision will vary depending on where the house is located. The tax rules in British Columbia, for example, look very different from the ones in Ontario. In the property transfer tax regulation for British Columbia, you'll find specific exemptions. The province shields residents from paying property transfer taxes on a spousal transfer for a principal residence and outlines rules for transfers between spouses pursuant to a written separation agreement. Try the exact same maneuver in Ontario without careful planning, and you might trigger land transfer taxes, trapping yourself with a sudden tax bill. Even if you successfully navigate the tax code, you still have to contend with family law. Homeowners frequently assume adding a spouse is merely a logistical formality that doesn't change the underlying reality of their marriage. The BC Family Law Act operates on a different logic. Under Section 81, the moment your spouse is placed on the title, they gain a presumptive legal right to an undivided half interest in that family property if you ever separate. So, while a quick spousal transfer might bypass a property transfer tax bill in British Columbia, it permanently alters the legal division of your family's largest asset. The stakes change when we look at the second common scenario. This happens when an aging parent adds an adult child to the property deed, attempting to simplify their estate and avoid paying probate fees later. Here is the catch. If that adult child does not pay fair market value for their new share of the home, Canadian courts do not automatically assume the parent intended to give them a massive financial gift. Instead, the law applies the resulting trust presumption. The court assumes the child holds the property in trust for the parent. This creates chaos after the parent passes away. Because the child doesn't own that share outright, siblings or creditors can legally challenge their claim. British Columbia uses a Torrens land registration system, where the title itself is supposed to be conclusive evidence of ownership. However, unwritten family agreements subvert this legal protection entirely. As seen here in the Land Title Act, if a trust is involved, a formal trust instrument must be filed with the registrar and endorsed on the title. If that isn't done, your supposedly clean title is hiding an undocumented legal mess. Defeating that resulting trust presumption in court requires hard evidence. The child has to produce a formally drafted deed of gift to prove what the parent's actual intent was before they died. Casually adding a child to a deed to cheat the probate system often replaces a minor administrative fee with a devastating, expensive legal battle. A property deed sits at a highly volatile intersection of provincial tax codes, family law, and estate law. The only reliable way to safely navigate tax exemptions with a spouse or to defeat the resulting trust presumption with a child is proactive documentation. You must build an airtight paper trail of your legal intent before you ever request an alteration to the land registry. If you want to add a family member to your deed legally and securely, you should not attempt to navigate these regulations alone. Visit paxlaw.ca to consult with an expert real estate lawyer. They will help you structure the property transfer properly the first time, ensuring your intentions are legally recognized. Paying to structure a transfer correctly today costs a fraction of what your family will pay to fight over it in court tomorrow.